Next slide. Now here, MRB, this is a dangerous scheme. We have always been advocating that there should be an accrediting body and accreditation of medical education. What is being put across? Criteria for hiring a third party agency. What will be the criteria for hiring a third party agency? Even if you agree that third party accrediting agencies in this country, none. If you take higher education, National Assessment and Accreditation Council. If you take technological education, National Accreditation Board. All government creations. Here is a Pandora's box. We agitated that there should be an accreditation mechanism created for medical education. Now they are creating what mechanisms? Non-statutory mechanisms, third-party mechanisms, which can be. It is not clear how it would be checked whether such third-party agency has verified as per rules and regulations. Legal responsibility also needs to be fixed. Considering all aspects, verification has to be done through assessment cell in the commission itself. Who will be recognizing these third-party agencies? Where is the modality of recognition? If the criteria are not fixed, modalities are not fixed, who will be bringing them into picture and with what modality they will be brought into picture? Empaneling a rating agency is, I do not know. I mean, if you are talking of panel of the agencies, then who will be empaneling them? Even, I mean, this is my opinion that I do not consider this to be a fair idea. It is not clear how it would be checked, whether such rating agency has verified and given rating as per. It is experienced that presently there are many rating agencies who give rating as per their own methodology, which cannot be said to be in consonance with regulations. This therefore strikes at the root of the autonomy. If MARB has to seek direction from the government, again same, what is applicable to them? President is empowered to take all decisions, and the three considerations which are applicable to undergraduate and postgraduate board, they are equally applicable to this rating board as well. Next. Now permission to start new colleges. Ladies and gentlemen, you need to bear in mind 1992 Parliament amended and included Section 10A in the IMC Act. I will give only two historical parables which are necessary to understand the magnitude of the grave wrong which is being inflicted. Prior to 1992, anybody could have opened a medical college anywhere without anybody's permission. It was in the year 1992 that Section 10 was amended to include Section 10A, and it said no medical college, comma, postgraduate course, comma, super specialty course can be opened without the prior approval of the Government of India on the recommendations of Medical Council of India, and procedure part for the same would be regulated by regulations under Section 33, and a separate entry was provided under Section 33. This regulation has resulted in enforcement of minimum standard requirements, periodic recognitions, renewal of recognitions, and therefore maintenance of the desired standards, at least by a monitoring mechanism. There may be loopholes, there may be wantings, I do not deny them, but a system is in place. Now here what we are proposing. The board is entitled for considering the submitted scheme for establishment of a new medical college by an applicant and pass an order within a period of 6 months from the receipt of the scheme in terms of the approval or disapproval, thereto with due regard to stipulations provided under Section 27(4), which amounts to vesting the board with the total authority. Total authority. Eligibility criteria, government verified. Technical criteria, medical council verified. Medical council had a right to recommend. Government was the approving authority. So the check and balance was worked out under 10A. So here there is no check and balance, because government does not feel any need of check and balance, because their committee, their appointee who is salaried, apart from that, their appointee who is to seek directions, apart from seeking directions, can be removed anytime. In such a situation, they have definitely created a department of their own for the purposes, instead of doing it in Nirman Bhavan, Now they will be doing it at Dwarka. So this is exactly, I mean, the conversion of a Nirman Bhavan into a Dwarka is something which is moralistically very appropriate. But this is not the way of such a conversion. And that's exactly what I'm wanting to put across. There is a proviso. Now here I'm wanting to draw it as if this was not enough, friends. There is a proviso. There is a proviso which contemplates that there could be a relaxation made for the medical colleges. What is the need of it? If minimum standards are necessary, can there be a relaxation of the minimum standards? And if they are to be there, can they be by regulations, or will they not be requiring the parliamentary approval through an amendment? They say, therefore they are open-endedly providing that there could be a relaxation made for which are to be set up in an unserved area which has not been defined. Now you define everything in the definitions. Where you wanted to give relaxation, the unserved area should have been defined. There was a common term which was used, which was called as Bimaru states. States took an objection, and that word is now out of the colloquium. Unserved has to be defined. Unserved socially, unserved economically, unserved. There have to be parameters. In the name of unserved, here is an absolute power where relaxations can be accepted, can build as to what is the scope, meaning and ambit of the said word, unserved. Who will define it? And why it has not been defined? Is it an accident that it has been not defined? Number two, suppose if a word is not defined in this act, this word could have been defined in any other act. There are other acts where the word unserved is defined. Why did you not import that word unserved area as defined in such and such act? That could have sufficed. But no, it has not been done. It is envisaged that permission to start a new medical college would be given on the basis of mere statement that adequate faculty and hospital facilities would be provided. This implies that permission to start would be given even if adequate faculty and hospital facilities are not available, which is not only conducive for the growth of medical education, but would also result in mushrooming of the colleges, which is desired. Number of colleges have to be more. This is perhaps the way in which that mushrooming is expected to be liberally permitted. Next slide. Permission to start new, well, I'm further wanting to draw your attention to. It is not specified whether the facilities claimed to have been provided by the institutes are to be verified or not. Granting permission to start a new medical college by virtue of paper verification without an on-site assessment whether it is going to be good, conducive, I am leaving it to the learned imagination of the all concerned. That's the prelude. That's the prelude. There is no mechanism to verify whether facilities as claimed could be provided have actually been provided or not within the prescribed time frame. Such sweeping provision without provision for verification cannot be said to be conducive and cannot be they can only amount to legitimizing the illegitimate. Now I am coming to BMR registration. 28.3, there will be a board president and 2 part-time members of the commission. Now here the composition is different from the previous 4. The composition is different. Why? I do not know. This dichotomy is difficult to reason out. I have not been able to understand the reason, therefore I am keeping it blind and open. But it is not defined clearly who will be the primary registering authority. In a federal polity, if you are not defining the primary registry authority, what will be the legitimization of your SMR and what will be the validity of your IMR? This is BMR. The ambit of its functioning is not being indicated explicitly as to what exactly it would be. It is envisaged to include organizations or associations of doctors within the ambit of regulation of professional misconduct. This is contrary to law as organizations or associations of doctors are not registered. The condition of registration is a condition precedent. You cannot call, I may be the tallest man, but a dwarf who is registered for the statutory purposes is far more desired than the tall who is unregistered. Who is going to fulfill this requirement? You are wanting to be acting big by acting small. A contradiction in its own right. It is envisaged to are not right. Code of ethics can be made applicable only to a person who is registered. unregistered person is as good as a quack. Hence, provision to include organizations, association of doctors is wholly illegal. It is unarbitrary. It is totally arbitrary. The Delhi High Court judgment which the IMA has procured should find place here to fortify what is being advocated. Next. Powers and functions, the provision has been brought out that in states where there is no union territory medical council, the same would be put into place within 3 years from the date of notification of this act, which is again an impermissible imposition on the autonomy of the government of the concerned state or union territory, as the case may be, and is inconsistent with the governing principles of federal polity. You can't impose. Government of India cannot dictate, and here the dictate is statutory. Within 3 years from the launch of this, you will have to create this. I mean, at least till date, such tenets and such sermons, statutory in character, have not been heard of. This is one such. In the very proviso, it has also been brought out that during